All right, my clock says 1:30, so we will get started. Thanks everybody for joining us. This is Homeline's April 23rd Minnesota Landlord Tenant Law during the COVID-19 pandemic webinar for landlords and property managers. My name is Eric Kauge. I'm the Executive Director of Homeline, and presenting today will be our Managing Attorney, Mike Vra, who you should be able to see in the video window. We are going to have a screen share presentation, as you can see on your screen, for the duration of the 1 hour presentation. And we'll have some materials available afterward. You'll get an email follow-up with a copy of the presentation and any other relevant things. We had a considerable amount of response to this webinar, and so we allowed folks to submit questions in advance. So Mike's going to take about 20 minutes or so to go through some pretty the most general overview of the issues that we are hearing the most questions from tenants and landlords and community members. And then we're going to go through some of the questions that were submitted in advance that are sort of most relevant to the most number of people, landlords and property managers. And then if we do have time at the end of the hour, we will try to get to questions that are submitted over the Q&A question box or over the Zoom chat. Again, because of the number of folks that are attending, it's just not workable to do this any other way through other than this webinar format. So that's what we'll be doing today. And so
just to be clear, Eric, people watching will not be able to speak. We won't hear a question from their voice.
Correct. Yep. So if you have a question, type it in over the Q&A question and answer system or the Zoom webinar chat, and we'll try to get to it. If there are clarifying questions throughout, we'll try to get to them too. All right, with that, we are recording this also, and we'll have it available on our website afterwards. So with that, I'm going to just do a quick introduction to Homeline, and then Mike will start off. Again, Homeline, we're a statewide organization that provides free legal education and advocacy services for Minnesota renters. Our main program is a tenant hotline. We've advised approximately 250,000 renters since opening in 1992. We do advise renters in 4 different languages: English, Spanish, Somali, and Hmong. And we have a staff of 17 that include attorneys, advocates, and organizers. We are statewide, as Mike mentioned, but we are a tenant advocacy service. So the information we're going to provide today is general advice, general information, general legal guidance on COVID-19 related tenant landlord issues, legal issues. We did get some very specific questions in advance. We are unable to answer those questions, but we're hoping to try to provide as helpful general information as possible today. So with that, I'm going to hand it over to Mike to kick us off on the training.
Okay, thank you, Eric. And what Eric was just talking about, the specific questions, essentially it was some landlords asking for specific legal advice about a very complicated situation, very lengthy emails. We don't advise landlords. We only advise renters. We're a tenant rights group, and we run this tenant hotline. But historically, we've done a couple of things with landlords. We've given speeches where we basically say, here's what the rules are, and here's how they apply. And we also wrote a book, The Landlord's Guide to Minnesota Law, which is still available, although I'm not sure how relevant it is right now because the rules are so fluid, which is why we're doing this presentation today. We're taping this, and again, I'm going to say the date because we're recording. It's April 23rd, 2020, so the Thursday. I fully expect that what I say today will be irrelevant at some point in the very near future. I don't know how soon, though. The rules have been changing frequently since mid-month, March of this year, for the COVID-19 pandemic that we're all dealing with. And so we're trying to say, these are the rules now. That's really our goal today, to let you know what the rules are now. And we're planning on doing something like this every week, although it might be more of a question and answer format going forward. But to start, we're going to introduce you to the things that we get the most calls about and are the most concerning both for landlords and tenants. We actually gave a speech yesterday, very similar to this one. In fact, we decided to use the same exact PowerPoint. We're just saying what the rules are right now, not what we wish they were, not what we plan on them being, but what they are right now. When we're talking about things that are theoretical, we'll try to point that out. When we're talking about things that are certain, we'll point that out as well. But what we're really dealing with right now is current rules governing landlord-tenant law in Minnesota. So to start, the eviction moratorium. This is the thing that all landlords and tenants are familiar with, or at least most in Minnesota are familiar with. Right now, a landlord, in most cases, cannot file an eviction, at least not meaningfully. In theory, they could file it, but it won't actually be heard by the court or even scheduled right now. And we're not even sure what will happen if a landlord were to file an eviction for non-payment of rent, for instance, right now. We think it might just get flushed out of the system when the courts open back up, which they're kind of partially closed right now. There are two exceptions to the eviction moratorium that the governor's order allowed. The first is kind of a vague phrase that the landlord can still evict a tenant that seriously endangers others, whether it's other residents or maybe the landlord or just others. So there's that exception, along with an exception found in a statute that's been around since the early 90s, 504B 171. You see it on your screen there. 504B is, of course, the landlord-tenant chapter of Minnesota landlord-tenant law, and that's where you find most of the rules that govern this area of the law. 171 refers to some lower-level crimes, possession of any amount of any illegal drug, a list of illegal guns like sawed-off shotguns, automatic weapons, possession of stolen property, and engaging in prostitution. So those are the two exceptions that a landlord can actually file an eviction for right now, today, that will get scheduled quickly. I can't remember the last time we looked. There were 2 or 3 active cases in Hennepin County. Not many. And generally, there aren't many evictions filed for these reasons historically. 93, roughly, % of evictions filed in Minnesota are for non-payment of rent. So it's not surprising that they aren't falling into these specific categories. Also, part of the moratorium from the governor is that the landlord must stop terminating residential leases during the pendency of the peacetime emergency that was declared by the governor. Now, we're in the second round of the peacetime emergency. The first one ended the middle of this month, April, but the governor has renewed it. And so a landlord giving a notice to vacate, if you're a landlord and you've given a notice to vacate for the end of April, for instance, and the tenant is still there on May 1st, normally, pre-COVID-19, the remedy for a landlord would be to file a eviction for holding over, is what that's called. Now you couldn't file that eviction because, frankly, evictions are not fileable in general. So terminating a tenancy in the middle of the peacetime emergency, not allowed. The Attorney General's office, the Minnesota Attorney General's office, has the power and direction to enforce this eviction moratorium. The fine is up to $1,000 and up to 90 days imprisonment. It's a misdemeanor. And we've seen the Attorney General actually go after a couple of landlords around the state, and they're trying to enforce this rule. I know the Attorney General's office is active, very active, in contacting landlords where they've heard from tenants where the tenant is concerned that the landlord might be violating this statute or this executive order, and convincing most landlords that they need to change course before they run afoul of the law. So one key part of the eviction moratorium order from the governor is that rent is still due. Some tenants are arguing that they shouldn't have to pay rent, or that they're allowed to do a rent strike of some type. But that's not what this order says. Maybe there will be an order in the future, we don't know, or maybe there will be some legislative action either at the federal or at the state level. I guess it could even happen at the county or city level. But right now, the rent is still due from tenants. The moratorium does not stop rent from being owed. Okay, Eric, go on to the next screen, please. Thank you. The most important question that most people are asking us right now is, how long does this eviction ban last, the state eviction ban? Again, it goes through May 13th. And what happens after May 13th? About May 14th, what will go on? Will there be a flood of evictions filed on that day? Honestly, we don't know yet. The governor can extend the peacetime emergency and maybe the governor will. We can't really be sure. There's been no certain indication from the governor's office that another peacetime emergency extension will occur. The legislature can also extend the peacetime emergency. The legislature can also end the peacetime emergency, but both houses of the legislature, the state legislature, would have to agree to end the peacetime emergency. I honestly don't know if there have been other peacetime emergencies in Minnesota's history. We haven't done a ton of research into it, but I don't think there have been many, if any at all. And so we don't have a lot of precedents to guide us through how enforceable these emergency peacetime declarations are, what happens if a landlord decides to challenge it in court. We don't know what would go on in that setting, how long it would take to get into court for a case like that, and what a court might do. But as it stands right now, May 13th is the final day of the state moratorium on evictions, but extensions following that seem certainly at least very possible and maybe even likely at this point. Okay, Eric, thanks. Which brings us to the next point. So I looked at the name of all the people that signed up for today's presentation, and I know many of these names, and I've seen many of you in person before. I've given a lot of speeches around the state to a lot of different groups, including about 200 landlord groups. And one of the things that I say almost every time when I give one of these speeches is that what I'm talking about almost exclusively is Minnesota law. When it comes to landlord-tenant law, state law is what matters the most. Sometimes there's a city rule that might play a part, and increasingly so, especially in Minneapolis and St. Paul. But federal rules in general don't really apply for landlord-tenant world, except for some discrimination issues. However, things changed late last month when the federal government has passed, so this went through the Senate and the House and signed by the president, legislation called the CARES Act. Gotta look up the phrasing here, the Coronavirus Aid, Relief, and Economic Security Act, which bans evictions from being filed, also bans charging fees, including late fees, until July 25th. This is the key part, July 25th of 2020. And then the landlord has to give a 30-day notice, which can only be given after July 25th. So I guess on July 26th, the landlord could give the notice for 30 days, which would push it out to August 24th or so, when the landlord could actually file an eviction if they're covered by the CARES Act, which brings us to the next slide. Who is covered by the CARES Act? I'm gonna do a spoiler alert here and go to the bottom part of this slide. Our best guess is 30 to 50% of Minnesota rentals are covered. This isn't just a blind guess, this is an educated guess. We know certain things that are covered. Pretty much anything that's covered by the Violence Against Women Act, VAWA, which is a pretty wide umbrella. We've given some examples here: public housing, Section 8 voucher holders, Section 8 project-based holding. But also, the bullet point below that, properties with federally backed mortgage loans. This is a lot harder to figure out who this applies to. There are Fannie Mae, Freddie Mac, things like that. The problem with this issue, the properties with federally backed mortgage loans, is you're going to have a lot of landlords out there that honestly have no idea whether they have a mortgage that's federally backed. Their mortgage was something they got at a bank because they happened to bank at that particular branch because it was in their neighborhood. And that's where they got their mortgage. And they don't know how their mortgage is ultimately secured. It might be federally backed, they're not sure. Probably the only way for them to find out is to contact their mortgage provider and say, hey, do I have a federal backing for my mortgage loan? Some of them might know, but many of them won't. So let's say a landlord files an eviction on May 14th, assuming that Governor Walz does not extend the peacetime emergency, and the tenant says, Judge, CARES Act. And that's all they say, CARES Act, Judge. They got to prove no CARES Act covered. What does a landlord do in that situation? Well, they might have a duty to affirm that they aren't covered by the CARES Act. We don't know what Minnesota will do with this. We have seen at least one other state, Michigan, their Supreme Court issued a very instructive set of guidelines on this very issue, the CARES Act and who would be covered. They are going to be requiring that landlords affirm, apparently in writing, that they are not bound by the CARES Act. So I guess requiring some sort of investigative work by the landlord to figure out whether they have a federally backed mortgage. This information, by the way, might not even be gettable for the tenant. The landlord might be the only party who has access to it. But if you have to affirm that this is true, you want to be right so you're not lying to the court, obviously, as a landlord. But it does set up a really tricky issue if the state allows evictions to be filed before the CARES Act protection has expired. We might have two different sets of rules for landlords throughout Minnesota, whether or not they can file an eviction or not. Okay, Eric, thanks. Minnesota courts currently, like I mentioned earlier, evictions won't be scheduled except for those exception cases that we talked about. There are a couple other issues that come up in our line of work, landlord-tenant law, ETRAs, emergency tenant remedies actions. So that covers a tenant that doesn't have any heat, or, well, heat isn't really a big issue right now, running water, hot water, not working sanitary facility, or other essential services or facilities. ETRAs are still fileable for tenants, and they can be heard. They can actually be scheduled, as can a lockout or an ouster or a utility shutoff. Those would all be eligible cases to be both filed and scheduled on a normal schedule, which are both very quickly scheduled in Minnesota. A rent escrow, which is the most common tool a tenant can use to convince a landlord to make repairs going through the court system, will not be scheduled now. They are considered a low priority by the court system, along with conciliation court. By far the most common type of case where a tenant sues a landlord is for the return of their security deposit. That case cannot be filed or really scheduled right now either. And so we're waiting to see when those things will change from the court's perspective. Also, another question is, how will court happen once court is available again? Will we be doing a lot of virtual court appearances, phoning in court appearances? We're not really sure what court will look like. Those of you that have property in the metro area and may have been to Hennepin or Ramsey County Housing Court in the past will have undoubtedly seen massive groupings of people. It's not uncommon for a calendar in Hennepin County that's supposed to be a 3-hour calendar or something like that to have 30, 50, 75 cases called. A lot of people crammed into a very small space. It's not built for that space. It's the space they have. Certainly not ideal in a COVID-19 world to have that kind of concentration of people. So how court will actually look post-COVID-19, whenever that happens, is as yet to be determined. Another couple things we should talk about, the price gouging limitation. So this does apply to housing. That's specifically mentioned in the governor's executive order. It defines what price gouging looks like. There's, first of all, a hard number that we can look at, more than a 20% increase, or the wording is a gross disparity between the price of the good and the price of the same good 30 days before the peacetime emergency. Again, the Attorney General is tasked with enforcing violations of this. The penalty is much more severe from a monetary sense, $10,000 per transaction. Price increases or rent increases, we've actually seen a lot of variation since COVID-19 has happened. I'm sure that if we took an informal poll of all the landlords that we're watching right now, there is some concern about whether your renters are going to pay your rent, pay the rent that they owe. You're also going to be concerned about whether you're going to be able to keep your buildings full, because I'm guessing you're getting some notices to vacate from tenants. People that are moving out, they've decided to move back in to their home, or maybe they've already moved, or they're going to take care of a sick relative, so they need to move for that purpose. So they're just doubling up because they're worried about their income. And so we've actually seen some landlords backing down. They'd issued a rent increase notice to tenants, and then they send out a letter a week later saying, hey, that rent increase we mentioned, we're actually going to keep our rent the same because we want to keep our customers, our good customers that are paying, and lowering their rent increase. And we've actually seen a few landlords lowering their rent, which is, I've done this since 1996, not something we've seen much of in the past. Landlords don't tend to lower the rent. They'll offer concessions, maybe a free month's rent if somebody signs a lease or something like that. But if a pure monthly rent lowering is really uncommon in our line of work, but we are seeing that some at this point. So a couple other points before we get to the questions that have been submitted. Can a tenant move? yes, a tenant is allowed to move in and move out of a residence. This was actually in question with the first governor's shelter-in-place order. There were subsequent FAQs issued through the governor's office that said that this was okay, and then the modified shelter-in-place order, the one where golf courses were allowed to open, for instance, indicated that tenants could, in fact, move in and move out of a place. Yeah. Oh, and I see a question. Somebody says, who's our line of work? I'm talking about landlord-tenant world right now. Obviously, Homeline is not representing landlords. But when I say our line of work, it's the landlord-tenant arena, that whole business that we all are involved in. The last key topic that I want to get to, because we are getting so many calls about this. We keep track of why anybody calls our landlord-tenant hotline. There's about 75 topics that we track. And since the middle of March, this topic, can the landlord enter my rental? We've seen between a 200% and 300% increase in calls about this for obvious reasons. Tenants are concerned about having anybody enter their home. All of us are concerned about having anybody enter our home. But the landlord has a key, and there is a specific set of rules that talks about when a landlord can enter. Now, those rules were written long before COVID-19 in the mid-90s, and they refer to a couple key things. The landlord must have a reasonable business purpose. They also have to try to give reasonable notice. But here's the phrase that honestly has never really held a ton of importance in analyzing the statute until the middle of March of this year. In quotes we have here, under the circumstances. Under the circumstances, is it a reasonable business purpose for a landlord to enter a rental? Now, if a tenant asks for repairs to be made, and they understand that the landlord is going to have to enter to make repairs, I think that's a clear situation where the landlord certainly has a right, and they're being permitted to enter the tenant's home. The harder question is showings, and we certainly are in the showing season. The summertime is when people move in, and when people move out. When tenants are planning on moving out, landlords want to show a rental. And in general, we encourage prospective tenants to want to see the actual rental for all kinds of good reasons. But we're in a different world now. And virtual showings are becoming kind of a standard between landlords and tenants, where they convince the current tenant to take a bunch of photos after they've cleaned the place up as well as they can, and they've straightened the place up. The landlord will then get the pictures, or maybe a video or both, from the current tenant and use it to show to the next prospective applicant. A lot of prospective applicants don't want to do physical in-person showings. They prefer to do really thorough virtual showings. And so we've seen a lot of landlords and tenants end up at that. There's sometimes a big standoff between landlords and tenants. Landlords saying, I have the right to enter, you can't stop me from coming in. That's tricky, actually, from a legal perspective. I'm not sure what remedy a landlord really has against a tenant that refuses to allow a landlord to enter right now, especially for something like a showing. The normal remedy for a landlord would be they could file an eviction. But right now, a landlord can't file an eviction for that purpose. So can a tenant just say, no, you can't come in? You can't enter. What happens if the landlord shows up? Well, maybe the tenant won't lift the chain off the door, or maybe they'll slide a dresser in front of the door and not let the landlord come in. Police might get called. The police are almost certain to say this is a civil matter. And so there's certainly no crime being committed by the tenant at that point. It's a tricky legal question. Like I said, most landlords and tenants are figuring out a way to do these showings as effectively as they can, with as minimal contact as they can. If there are to be showings, the realtor approach is ideal. And what I mean by that is the tenant leaves all the lights on. The current existing tenant leaves all the lights on. They open all the key doors, right? The door to the bathroom, the door to the bedrooms, the door to the closets. And the landlord provides and insists on masks and gloves for anybody coming in. This is sort of the settlement that if a landlord is going to do the showing and the tenant wants the showing to happen, or they're okay with the showing, seems to be what most landlords and tenants are ending up on. Trying to be as sensible about this as possible. But again, the virtual showings are increasingly happening at this point. I think, yep, that was our last slide. Now, Eric, if you're ready, we can start with the questions that we've gotten.
Yes. And again, just to let folks know, we have received quite a few just today on the during the webinar and quite a few before. So we're trying to respond to the most frequent, most common that are applicable to as many people as possible.
And our plan is to do this on a weekly basis. And
Yes.
next week, I assume we'll be doing much more of a question and answer session because we've done the introductory things, unless a rule changes. And then that'll be our primary focus at the beginning. Then we'll open it up to questions and answers again.
And the registration for next week's webinar is already open on our website, but we will send follow-up info on how to register. It'll be the same day and time of the week, Thursday at 1:30. All right, first question. What's the best way to document repayment agreements? Is there any downside to accepting partial rent payments?
Okay, good. It's a good question. And a lot of landlords actually sent repayment agreements on April 1. Very big landlords throughout the state sent these. They weren't even requested by the tenants, but landlords were sending them out saying, hey, we realize you might not be able to pay all of your rent. We want you to tell us what you can pay and when you can pay it. And in exchange, most landlords in that setting were waiving late fees. Now, the governor's order does not waive late fees specifically. The CARES Act does. It doesn't allow the late fees, but the governor's order does not ban late fees. So a landlord waiving late fees is an incentive that a landlord can offer to a tenant. I don't see much of a downside for a landlord accepting partial payment if there's a written agreement. I've heard landlord attorneys throughout the years, when I've heard them give speeches, they've heard me give speeches as well, but I've heard landlord attorneys through the years talk about how landlords should never accept partial payment, which I think is really good advice if your goal as a landlord is to win evictions. If your goal as a landlord is to collect rent, I think you have to look at partial payment offers, and right now more than ever. And so what the statute that actually creates a defense for partial payment for an eviction says is that the landlord and the tenant are supposed to agree in writing what the partial payment means. And if the partial payment says something like, let's use $1,000 for rent, that the tenant will pay $500 rent on the 3rd, and will pay the landlord $200 more on the 21st, and then another $200 on the 1st of the next month, or whatever numbers and dates you want to put in. But the tenant fails to make any of the payments, then the landlord has the right to file the eviction after the missed payment. That's really what the partial payment defense wants, or statute wants a landlord and a tenant to agree to, but agree to in writing. So the most important part of a partial payment agreement is that it's done in writing. I like it honestly from both sides. The tenant knows what it is. They can see what it says. It doesn't need to be notarized. It doesn't need to be drafted by a lawyer. It just needs to say what everybody is agreeing to and what the consequences are if the tenant doesn't live up to what they're saying they will pay. But yeah, that's the main thing. I would encourage landlords to do partial payments right now to keep your income coming in. Tenants want to pay in general if they can, but they're not sure that they're going to be able to.
For federally assisted housing, can a landlord proceed with eviction started before the moratorium when the state lifts its moratorium?
For federally assisted housing, no, the landlord could not proceed with the eviction. If you switch the question around, though, if it's a place that's not federally backed somehow, or there's a federal subsidy in place, then the landlord could file an eviction after the moratorium. Was that the question, or was it had it started before the state moratorium?
If the eviction had started before.
Oh, I'm sorry, if it had started before, then yes, those are not banned. I mean, that's going to be a limited number of cases, but yes, that could be sustained still, as long as the court allows it. I'm not sure what the court has done with all the existing cases. Again, we're in a lot of different bays of uncharted waters, and this is one of them. We're not sure what the court did with all the active evictions when the moratorium was issued, and we'll find out when the moratorium gets lifted, probably.
It would make sense if tenants get help with rent, then why not have it paid directly to landlords?
So some of the programs that are offering assistance do just that. They pay directly to the landlord. I believe the Minneapolis, and you can back me up on this one, Eric, the Minneapolis fund that was just made available, was that yesterday or today?
People can start applying as of yesterday.
They can start applying as of yesterday, but I believe that pays directly to the landlord. Is that right?
I believe so.
Yeah. Compared with, for instance, the federal stimulus package, the $1,200 check that we have all heard so much about in the news, that is not directly to a landlord. It's not earmarked for rent. It's not earmarked for anything. It's just a payment to anybody that qualifies for that dollar number. And so you could argue that the landlord should get that money first, or that they should have a first right, but that's not part of the legislation that was done at the federal level. But some of these local, I know the Minneapolis, St. Paul, I believe Bloomington and Edina have also come up with some extra money for housing issues, and they may go directly to the landlord. And that might be part of future payments as well. I know that the state legislature is kicking around a couple versions of this, and I think that both of those have payments going directly to the landlord as well.
The name of that in Minneapolis is Minneapolis Gap Funding. If you just Google that, you'll find that page on their on the city's website. Can a landlord send a notice to evict or vacate letter now for back rent and file eviction on day suspension ends?
Okay, so built into that question is this concept that a lot of people get confused about. A landlord doesn't need to give a notice if a tenant hasn't paid rent. Minnesota is one of only 7 states where there's no written notice required in general for a landlord to evict for non-payment of rent. So the answer is yes, but not really for the reason I think the question is asking it. A landlord in a standard Minnesota lease, the day after the eviction moratorium is lifted, can go file an eviction for non-payment of rent. No notice is necessary under the current rules that we have.
If people sign a housing agreement this summer to live in a tiny home, can we evict them if things go south?
Okay, I'm not sure that there's any specific different rules for a tiny home. I haven't heard of any, and I'm not exactly sure what the cutoff is for a tiny home or not. I've seen the stuff on, my wife is an HGTV addict, so I've seen the tiny home shows on occasion. But I don't think there's any special set of rules for tiny homes versus any other rental. But can a landlord file an eviction this summer? Maybe. It depends on what's going on. First of all, if that place has a mortgage that's federally backed, you have to wait till July 25th if the rent isn't paid. And we also have the state eviction moratorium. We don't know when that will end as well. So I don't think, again, part of that question is, are there different rules for this tiny home? Don't think so.
We've had numerous questions about trespass and squatters.
Okay. So yeah, that's one of those phrases that we get asked about a lot on our tenant hotline, and landlords will ask me about squatters and trespassers. So a trespasser is somebody that takes possession illegally of a place. That's what it requires. It's not somebody that held over after a lease was over and stopped paying. They have to take possession illegally to be a trespasser in Minnesota. And so that's a pretty rare case. I mean, it happens, but it's pretty rare. And then when we get to a squatter, the key question with somebody, defined as a squatter somehow, is, do they owe rent? Have they ever paid rent? And if they do, then they probably fall into the rights of a tenant. So I've heard landlords in the past define squatters as anybody that's there that isn't current on their rent. That's not what a squatter is. If they owe rent in Minnesota, then they have the rights of a tenant. So then the landlord would have to file an eviction like every other landlord. And again, right now, that might be virtually impossible to do.
And sorry, one second. What happens if or when a resident or staff member comes down with COVID-19? What are best practices?
Yeah, that is a tricky question. I can tell you the stuff that we've heard that landlords are doing with the few tenants that we've talked to that have actually contracted the COVID-19 virus. The first one is landlords have been incredibly helpful in general. They're offering to deliver the mail directly to the tenant's door to make sure that groceries are picked up for the tenant and delivered to the tenant's door. Essentially doing everything they can to encourage the tenant to stay in their home. And that is what you can do as a landlord to try to solve this problem. There's not I get to evict somebody because they've contracted the COVID-19 virus. That doesn't exist. That concept. I suppose you could argue that the person that's contracted it is endangering others, but I'm not sure that that's going to hold up in court. We haven't seen any cases filed like that yet. And so this really is sort of common sense stuff. How can you make sure that the people don't need to leave their home if they've contracted the COVID-19 virus? As far as staff, that's a different question. And part of that bleeds into employment law, which I'm by no means an expert at. When it comes to the housing, though, most caretakers, if that's what we're talking about, I'm not sure if it is, are also tenants. So they're kind of half tenant issues, half employment issues. And just like a regular tenant, it might be difficult to remove them if that's what the question is trying to figure out how to do or not, because the eviction might not be available.
What legal action can a landlord take if a tenant is refusing to renew a lease during COVID-19?
What legal action can a tenant take if the landlord?
What legal action can a landlord take if a tenant is refusing to renew a lease?
Oh, if the tenant's refusing to renew the lease, well, I mean, look, if a lease ends, then a tenant can simply decide to not stay, right? As long as they give proper notice, they're allowed to leave at the end of their lease. So there's, I'm not going to lie. I mean, this is a unilateral rule where the landlord can't file an eviction, but the tenant is allowed to give a notice to vacate and to move out when their lease ends, just like has always been the case. That hasn't changed under the new rules. That's just how the governor wrote this. I guess the governor could have said that nobody can move out. That could have been a rule, but that's not the rule that was enacted.
How are lease agreements affected? What if tenants have a disruption in income? At what point would they have to pay all rent?
Well, again, the rent is due. Legally, it's due. There's no question about that. The question is, what remedy does the landlord have against the tenant if they don't pay? And as we've talked about, a landlord really can't file an eviction right now for non-payment of rent. It just doesn't work. So it's a matter of when can the landlord file it? And it's that two-part answer, which is depends on whether or not it's federally backed or federally subsidized. And if not, when does the eviction moratorium end at the state level? Well, once those two things happen, or one of those things happens, depending on the situation of the landlord, then the landlord can file the eviction. But until then, there's not much of a remedy for the landlord against the tenant, not legally.
Can we as a landlord give a tenant notice to move as long as we give them the full notice, i.e. 2 months, not an eviction, just non-renewal?
Right, and so that question obviously understands that there's a difference between an eviction, a UD, an unlawful detainer, and a notice to vacate or a non-renewal. The key distinction is there's a court case filed with an eviction, right? A non-renewal or a notice to vacate is where the lease has ended, and the normal rule is that a landlord or a tenant can say, hey, you know what, our contract ended, our one-year deal ended, we don't want to do another 1 year, or we don't want to do another month if you're month to month. Either side is allowed to give a notice ending the contract at that point. Right now, that would be something that fits into the governor's moratorium where it's terminating the tenancy. And that's not allowed to happen. There is a question, a legal question, about whether a landlord could give a notice today, let's say for the end of June, right? We're in April, a lot of leases require 2 months notice. So can a landlord non-renew a lease for the end of June? So the question is that terminating the lease during the peacetime emergency? I think there's a pretty decent argument to say that there is a violation. I'm not sure that the Attorney General's office is enforcing that, but it is an open question. However, if you have given the tenant a notice to vacate or a non-renewal effective for the end of April, and the tenant stays into May, clearly you can't evict them for holding over at this point, at least until the eviction moratorium is lifted.
Renter broke lease before the virus rules took place and is in jail. How do I retake possession of the home to get it ready to show?
That is difficult. There's so many layers to that question. That would be a hard question pre-COVID-19, and it's even worse right now. Easiest way out for the landlord in this situation is to somehow get some authorization from the tenant who's in jail to allow them to empty the place out. Maybe they can have a friend or family member come over and grab their property and authorize the landlord to re-rent to somebody else. In theory, and probably in practice, that tenant might be running up a bill. I'm not sure if the landlord's ever going to collect that money from that former tenant, but they probably owe rent until the end of their lease or the place gets re-rented. And so it's probably in everybody's best interest, depending on how long they're going to be in jail, to re-rent the place to somebody else, including the person in jail. It's a matter of somehow reaching them and getting an authorization somehow from them that they are going to reauthorize the landlord to rent to somebody else.
Where are the protections for landlords with the governor's executive order?
In my mind, the single biggest protection for the landlord in the governor's order is the phrase that rent is still due. The governor did not have to say that in their order. And I know there was political pressure on the governor, and there still is political pressure on the governor, on the legislature, on local elected officials, and even at the federal level to waive rent being due. And that was not done in the governor's order. And so that is ultimately the key thing I think that landlords can still point to and say, hey, look, the governor said the rent is due, to a tenant that's saying, I'm not going to pay my rent. You can't make me pay my rent. And right now that's true. The landlord can't make the tenant pay the rent. But eventually, these eviction moratoriums are going to be lifted at the federal, state, or both levels. And at that point, the tenant is going to owe the rent that they owe, whether it's full payment or a partial payment.
And I do want to point out, kind of related to this question, is that just yesterday, our organization stood by Minnesota Multi-Housing Association in testifying on a bill to try to get rental assistance from the legislature. So just know that there's efforts to try to deal with that situation. The next question is, in regards to filing evictions for unpaid rent, what advice would you give to landlords if the governor extends the peacetime emergency executive order currently in effect until May 13th?
I'm sorry, give me the first part of that question again, up until the governor's order.
In regards to filing evictions for unpaid rent, what advice would you give landlords?
Yeah, again, there's not much of an option for you. I guess you can tell the tenant, hey, look, an eviction is going to be filed the day I have the right to file, unless you start coming up with some money. And that might compel the tenant to, once they qualify for unemployment that they've been waiting for, they get the stimulus check, they might prioritize paying the rent, which today they might not be prioritizing simply because the landlord can't take action against them. But if you remind them, hey, look, the governor's order says rent is due. And as soon as I'm able, I'm going to have to file an eviction because I have to get somebody in here that's paying, might be enough to convince the tenant to pay. But if they refuse, the remedy that landlords have, the one hammer that landlords really have when it comes to landlord-tenant law, simply isn't in the toolbox right now. Evictions just aren't available.
Next question. We occasionally have a tenant who will state they received legal advice from Homeline. We have found that sometimes the tenant gives us a skewed interpretation. Is there a resource available, or could there be through Homeline to get clarification without us having to pay an attorney? It would be helpful to have resources for both sides, which would in the end give us better results in partnerships between tenants and landlords.
Yeah, I don't fault anybody for asking this kind of question, and I've noticed several questions have popped up in both the chat and the Q&A box about this as well. Who do we call if we have a direct question? There's no Homeline equivalent for landlords. We are a free tenant hotline. We advise renters around Minnesota. We take about 15,000 calls every year, and we talk to each person individually, or else they email us directly with their questions. And there's not really a landlord equivalent. Eric just mentioned a place called Minnesota Multi-Housing Association. It's a landlord group. They have several pre-recorded pieces of information on, I don't remember, the 20 biggest topics that they get questions about, and they try to answer some questions that way. I'm not sure that they run a hotline. I know they did at one point, but we're obviously not affiliated with them much, and so I don't know if that's an active hotline or not. A landlord can call the Attorney General's office. A couple things they'll do. Number one, they have a handbook that they publish, so it's free, that anybody can get, or they can download it online. They can also advise both sides, although they don't give legal advice. But short of that, we're a tenants' rights group, the people that fund us, which is a lot of foundations. There's some government money, but it's not the majority of our funding. And a lot of donations pay us to work on behalf of renters. And the reason why we even give speeches like this to landlords is we're trying to make sure landlords have, you know, a good baseline understanding of what the rules are, because in our experience, landlords that understand the rules tend to follow them. I wish there were a group out there that was able to provide free advice to landlords on a hotline kind of situation, but to my knowledge, it doesn't really exist.
Next
question. A question we're getting is, why can't we advise landlords? Well, here's the thing. I'm an attorney, and we have several attorneys on staff. I think it's 6.5 or 7. Quite a few are half-time attorneys. And we advise renters. And if I advise a renter today, and the landlord calls me up tomorrow and I advise the landlord, then I've just advised two sides of a conflict. It would be a conflict of interest. And I wouldn't be a lawyer for long. I'd actually lose the law license, because you're not allowed to do that, not allowed to advise both sides of a conflict. So that's why we do not advise landlords.
So there are, and you mentioned it, and we'll put it with the materials on our website. We're going to post the recording of this video on our website, include the PowerPoint, and then we'll try to include some links to, like, the Attorney General's handbook, multi-housing associations. They do have a page that has some updates about COVID-19.
Right. Again, it's one of those things I wish existed. I know that there are many landlords around the state who actually tell tenants, you know what, if you don't believe me, call Homeline. And you might not believe this, but one of the most common pieces of advice we give tenants is, hey, what your landlord is doing is legal, but they need to hear it from somebody who's not their landlord. And so I wish there was some agency that, you know, landlords could contact to figure out what the rules are. But like I said, I just don't know that it exists.
All right, next question. Can you evict a tenant for other lease violations that is not related to non-payment?
Yeah, in general you can, but again, during the COVID-19, it has to be one that either is the drugs, guns, prostitution, or stolen property, or endangering others. Somebody has a dog and they're not supposed to. Can't file an eviction for that right now. Somebody has an unauthorized occupant. Boyfriend or girlfriend has moved in and they're not on the lease. You can't evict for that right now. But that's simply not allowed under the moratorium that we have in the state.
There was a comment that came up that I think helps on the last question, asking about conflict resolution or mediation services. There definitely is, and we'll put a link. There's like a statewide organization that has links to conflict resolution and mediation organizations that are throughout the metro and throughout the state, and we have seen those services work well. And I know that there's some of them, if not all of them, are still in operation. Sorry.
Okay. What's the next question, Eric?
Sorry about that. I muted. Okay. Next question. I'm wondering if there's been any indication of a new vision for housing court proceedings. Certainly, we won't be cramming into hallways and courtrooms anytime soon. And even if we could, that hasn't been the most productive method for conducting hearings.
Right. We talked about that a little bit earlier. I think that at first, video court cases are almost a given to happen. Honestly concerned about that from a tenant perspective. Again, not every court in the state is like Hennepin and Ramsey County Housing Court, but these are really, before COVID-19, they were really hyper efficient court cases. Again, I mentioned there might be 30, 50, 70 cases in a 2-hour block. You got to get through them pretty quickly. And a lot of times the tenant doesn't get much of a chance to speak if they're there. Frequently, tenants don't even show up because it's a non-payment of rent case. They don't have the rent. They don't think they have any defenses. But if they are there, there's only so many defenses that really work. But it is kind of a machine-like setting. And I'm just not sure how well that machine works in a video version of courts, or whether people are phoning in, or if it's going to have to be where they do 10 cases at a time and just have to have calendars constantly going. It's not really clear exactly how that will proceed. And it's not just going to be evictions, it's going to be all courts.
Yeah, and so the kind of the follow-up question is, maybe you covered these. Is there an indication phone or video conferencing? Could the court for settlements, for court proceedings, those types of questions? Yeah,
I think the settlement possibility has a lot of attraction. Many landlord-tenant eviction cases are settled because, again, it's about money almost every time. And so the tenant comes up with some sort of payment plan. they've started a new job, or they've got a new form of income that's going to be steady for them. And could a settlement agreement be reached and then agreed to and then sent to the court somehow, which the court has historically discouraged, although I think now they should be more likely to encourage that kind of solution between landlords and tenants, because it's probably going to have the same effect ultimately. It would miss out on the in-court mediators that are available in the Hennepin and Ramsey County and available in a couple other counties now around the state. Yeah, I think that there's a greater likelihood that those will be granted.
Next question. I'm a homeowner and I've decided to rent a room to a male tenant. I've recently received threatening texts from him. I'm wondering if these text messages are enough to have him removed during the stay-at-home and eviction orders.
Maybe. You might win an eviction. You might be able to file an eviction saying that you seriously feel endangered by the tenant. So it might be one of those narrow groups where a landlord could file an eviction. You could also call the police. I mean, if you actually think there's a threat, a credible threat against you, they may take action. There might be some other options available for the landlord there.
And a question just, can you just give us the list of the allowable reasons to evict during COVID-19?
Sure. Again, number one is the tenant seriously endangers others. And then everything else is found in the statute. It's illegal guns. Once again, it's sawed-off shotguns, automatic weapons. There's a list in the law of which the illegal weapons are. Possession of illegal drugs. It doesn't have to be a giant amount. 1 grain of marijuana left in the ashtray from 2 weeks ago is enough. Prostitution, engaging in prostitution, or possession of stolen property. That's the very narrow list of allowable eviction topics right now.
And drugs is included, marijuana is included in that, even if
marijuana is included in that. Yeah, pretty much everything you'd guess would be on the list is on that list. Marijuana is still not legal in Minnesota in general. A lot of other states it is, but it's not in Minnesota. Alcohol, if you're under 21, is not on the list. Maybe the most striking omission, but it's not there.
Can a landlord ask for proof of the tenant that they were financially impacted?
Landlord can ask, and I think some of the local programs are requiring that information be disclosed or sworn to by the tenant. For a standard payment plan between a landlord and a tenant, I mean, again, a landlord can ask for that, but it's not a necessary inclusion in a payment plan. Although if landlords want to ask for it, there's no law that says that they can't.
You maybe covered this a little bit, but what if a renter agreed to leave and you have a new renter sent to move in on the 1st, but the first renter changes their mind?
This is the nightmare stuff, right, for a landlord, no question about it. So we'll just use the calendar here. Tenant's supposed to leave on April 30th and they don't. They stay there into May 1st and the landlord is re-rented to somebody else May 1st. The normal remedy for the landlord is to go file an eviction against that tenant. Now that's somewhat useless pre-COVID-19 actually, because it takes 20 to 30 days under the old system to evict somebody. First of all, we don't know how long an eviction is going to take once they restart. There's been some legislation. The normal old rule was that an eviction had to be heard within 7 to 14 days of the landlord filing it. Now that seems to be relaxed. The court can do it within 7 to 14 days, but they could also go longer. So anyhow, the normal remedy for a landlord would be to file an eviction against that existing tenant, remaining tenant, for holding over. But right now they can't file it. On May 1st, they can't file it. They'd have to wait till the eviction moratorium is lifted. And then it would still be the length of the eviction process. And so it's a terrible spot for, well, honestly, for everybody. The tenant that's remaining, the existing tenant, is probably going to have a bill for something, right? Because the tenant that was supposed to move in is incurring a bunch of expenses. And they might try to pass those expenses on to the landlord who was supposed to provide them a place. Maybe they kept the rental truck longer. Maybe they had to stay in a hotel for a few nights. Maybe they had to get a different place and it was a couple $100 more a month. So they sue the landlord for that amount for the whole term of the lease. The landlord is almost certainly going to try to pass that cost on to the remaining tenant. So it's not an ideal situation for anybody. It's just the spot we find ourselves in right now is that that landlord can't file that eviction on May 1st, which they normally could.
All right, we have maybe 5 minutes or so left, trying to get to some of the questions that came in today. What happens when the landlord states categorically they don't want the rent because they want the tenant to leave?
It depends where we are in the lease to start with. I mean, if it's a month-to-month lease and we get past the eviction moratorium, the landlord can say, I'm not going to accept the rent. Yeah, accepting rent means quite a bit in general. It means that the landlord is allowing the tenant to stay, but it still wouldn't grant a landlord the power to file an eviction right now if they refuse the rent. It just doesn't mean much of anything legally because of this eviction moratorium that we have.
CARES Act only covers non-payment.
I think that is right, and I don't have it in front of me, and we haven't seen any court cases on it yet. But my reading of it is about non-payment. The CARES Act is, yes. But again, that's almost every eviction in Minnesota. So,
what happens if a tenant changes their lock to try to keep the landlord out?
Yeah, and we talked to some tenants that have talked about doing that. Normally, the ones that are doing that are immunocompromised, and the landlord says, I'm coming in no matter what. Normal remedy for the landlord, once again, file an eviction. Not available right now. They have to wait until the eviction moratorium is lifted in Minnesota. So, yeah, there's a cost to the tenant. I think that under most leases in the state, the landlord's going to argue that you're destroying or altering the property. But the tenant says, you know what, I've got this illness, and if somebody comes in and I get COVID-19, I'm, in the very high risk group, so I'm going to change the locks. Again, the normal remedy is the eviction to file, but that's not available for the landlord right now.
Can a landlord raise the rent when renewing the lease, or if the lease transitions to month, then raise when things open up?
Yeah, I mean, look, the landlord can raise the rent right now as long as they don't go above the price gouging limitation that the governor had in their order. And I got to say, from years of experience of doing this, raising the rent over 20% is pretty exceptionally rare. I've seen it sometimes. Usually the only time I'll see that is if you've had an owner that owned a building for 20 years and a tenant that was there for most of the 20 years, and the landlord just didn't raise the rent much to keep up with the market. Then a new owner comes in and says, hey, I've done a market analysis. This place is worth a lot more. I'm going to raise your rent up to the market rate. That's pretty much the only time I see a 20% or more jump. But a landlord can raise the rent right now. There's no law against it. It's just market-wise, I'm not sure how viable that is. It depends on your local area and what you're selling, obviously.
What exactly is considered endangering other tenants pertaining to evictions?
Yeah, I don't know. I think it says seriously endangering. It's a pretty vague couple of words, and I don't think I've seen any evictions filed for that phrase. The ones that have been filed have been for the violation of the drugs, guns, prostitution, stolen property since COVID-19 kicked in.
Do I have to let city inspectors in, or can I make them wear PPE?
That's a new question, and it's a good question, actually. If the tenant has invited the city inspector, then yes, I think you have to let the city inspector in. If it's some sort of routine inspection being done by the city, like they have a 3-year cycle, first of all, I'm not sure how many of those are happening right now, but if it is, that's a different question. I think I would certainly try to pressure my city officials saying, hey, look, if they're coming in, we got to make sure that certain safety guidelines are met, because I don't want to be blamed for my tenant getting sick or my staff.
What happens to balances owed from previous tenants? Can landlords still send account to collections? Is it reported to credit agencies?
So I'm not sure about what that question is asking. I think they're talking about sort of in the future when the COVID-19 crisis is gone and the eviction moratoriums are all gone. Could a landlord send a bill that a tenant owes to a collection agency? Yeah, sure. They do that now. They've done that before, and they can do that eventually. This debt is still due. So yeah, a landlord could go to small claims court, conciliation court for up to $15,000 in Minnesota, or they could turn it over to a collection agency and try to collect that way. Those are the traditional ways to do that. I'm not sure that turning it over to a collection agency right now would be allowed, and I don't know that I've seen a landlord try that. Might be a way to bypass the whole eviction moratorium. I suppose the Attorney General might say, hey, look, you're trying to evict somebody by scaring them through the collection effort. I don't know. Haven't seen that case taken on by the AG's office, or even we haven't even gotten many calls about it yet. Again, the normal remedy for most landlords, because they want to get possession back, is to go file the eviction.
I'm not sure we can answer this, but I wanted to raise it, and just because folks might know more about it. The newspaper reported that Hennepin County will allow late payment of property tax. And is it possible that that might be happening in other counties, and how do we get information about that?
I'm sorry, I do not know the answer to that one. We've heard all kinds of things that are being delayed, right? That your income taxes can be paid later, and so that wouldn't surprise me if more taxes are allowed to be paid later. But it's something you'll want to check with whoever it is you're paying your taxes to, whether it's a county or state level.
So we've hit 2:30, and we want to respect everybody's time. We thank you for joining us today. We are going to, you'll get a follow-up email within a day or so with a link to the recording and as many of the materials as possible that people have been asking about. And again, we are hosting another exact same webinar next Thursday, same time. That's April 30th at 1:30. Also will be an hour long. The registration's already on our website, but we will include a link to that in the email. Thank you for joining us.